Good afternoon. Hope you're well. Not legal advice. Please subscribe, like, and share, etc. Please help or offer to educate others as to legal matters besides trying out bad jokes, which I often try. I'm attempting to simplify the complex legal world, so that's the purpose of the channel. So today's episode, I'm talking about Diaz versus Tesla. And in this case, even though if you're not familiar with the case title, you may be familiar with the verdict. There was a verdict that was set in a racial discrimination case that was set in Fremont, California. The award was approximately $137 million, so it became a big deal. So now I'm going to go into the basics of it and what is occurring in the near term. That will be of interesting note to everybody. So the case itself is set in San Francisco, California. It related to a contract elevator operator at the Fremont plant in or about 2015 and 2016. As Mr. Diaz was a contract worker and did not have a direct contractual relationship with Tesla, the arbitration provisions that I addressed in an earlier video did not apply, so that this matter was litigated. It was litigated in federal court as it turned out. Now, the facts as proven at trial was that Diaz was harassed constantly at the plant in Fremont in 2015 and 2016 by employees and supervisors on a racial basis. The evidence was clearly adduced at trial that that was the case. There is no proof that such conduct is occurring today, and as I will address in a future video, attempts by California agency in charge of that on multiple occasions has been denied with respect to claims of racial discrimination at the Fremont plant. But this case is still ongoing. So there was plenty of evidence presented as to conduct that was inappropriate. Tesla basically denied it and then asserted that the damages should be less. That was basically their defense. In April of 2022, a federal jury unanimously found in favor of Mr. Diaz, finding in violation of Section 42 USC of Section 1981 of the code, basically amounting to a hostile work environment. And that was because of all the derogatory language that was directed at Diaz by the employees and by the supervisors. So the jury was out about 3.5 hours and came back and awarded Diaz $6.9 million in emotional distress. So that was for his claimed emotional distress working at Tesla and the abuse that he incurred. Now, that was taken into account with the caveat that sometime after that, Diaz brought his son to work at the same plant. So that's a curious conduct, but those are the facts. Of that $6.9 million award, $4.5 million was for past emotional distress, and $2.4 million was for future emotional distress. And those numbers are just basically made-up numbers. A lawyer will ask for an amount, but proving a specific amount for emotional distress is not really, you're not really able to do that. So you're just asking for numbers and hoping to appeal to a jury. On top of that, they awarded $130 million in punitive damages. Now, punitive damages are designed to penalize a defendant for misconduct. Now, again, even though the trial happened in 2022 and there was no reports of or any established evidence of this continuing up to that, still the jury was trying to penalize Tesla with this very large punitive damage award. So, in response to that award and the request of Tesla, the judge, and he's allowed to do this, reduced the amount of the award. So instead of $6.9 million in emotional distress damages, he reduced it to $1.5 million. Still a lot, especially for an elevator operator, but I'm sure he suffered there. So that's what the award was. And the punitive damage award was reduced from 130 million to 13.5 million. And the judge did that because there's a question, a constitutional question of how much punitive damages can differ from actual damages. In this case, actual damages, according to the court, ended up being $1.5 million, and he believed he was limited to 9 times, or approximately 9 times, uh, actual damages for punitive damages, and he came out somehow with an award of 13.5 for punitive damages. So the total award ended up being $15 million. Again, a substantial sum, a large portion of which the attorney took, at least a third, probably 40%, could be up to 50%. So that was the award of the court. The jury came back with a higher award. The judge reduced it based upon request, and that's what the result was. Diaz was offered to take that $15 million, or because this was in federal court, he could have a new trial on the issue of damages only. Tesla filed a motion for new trial because they wanted a new trial on liability plus damages. And they felt that if there was only a trial on damages, that would be unfair to them. The law seems to suggest that you can have a trial just on damages. So the court was supported by case law in deciding that it could have a separate trial just on damages. Diaz, again, didn't accept the $15 million. And if you saw my prior video about losing a trial step by step, it's quite a risk for him because he's going to be in front of the same judge who made a finding about damages being too much. And so, notwithstanding whatever the jury awards, seems like there might be a cap to what the appropriate amount of damages would be. And there's a very decent chance that the award could be lower. So that's a risk I see, and I'm wondering if the attorney may have shaped that decision. But there is one thing, or one reason why they would not take the 15 million, because Tesla is likely to appeal either way. So if the result, whatever the result is, Tesla will appeal. If Tesla appeals and Diaz would have accepted the 15 million, he could not contest the reduction from 136.9 million to 15 million. He would just only be able to address the $15 million amount. So there was a strategy for not accepting the 15 million, but it does risk a lot. And I'm sure, as I indicated, Tesla will, notwithstanding whatever the result, will attempt to appeal and will seek a reversal or reduction, whatever the result is. And this is in part due to the new legal team and new efforts that have been imposed on the Tesla paradigm. It'll be interesting to see, again, how Tesla and Elon do in a San Francisco federal court. That does not seem to be the environment that would be certainly consider the interests of Tesla. However, in the recent trial involving tweets and damages that were allegedly incurred in 2018, that was against Musk and Tesla, that was also in San Francisco, Tesla and Elon prevailed unanimously in front of that jury. So even though it doesn't seem to be a friendly jury pool, we don't know how it's going to turn out. But trial on the damages issue is currently set to start on March 27th, 2023 in San Francisco. It may be delayed, but that's what it is currently set to start. So I will be following it up and reporting back on this, because this happened to be, when announced, the largest verdict of this type ever in the state of California, if not in the country. And even though the likelihood of these claims arising again is less likely because of the arbitration provisions and also because, obviously, in a change of supervision and attitude, there may be other plaintiffs that might have claims that would jump on and continue and pursue them depending on the outcome of this particular claim. So it'll be interesting to see how it turns out. I will keep you updated, and once the trial begins, I will let you know how it turns out and what the result is on the damage issue. It'll be interesting to see how the court does impact any jury ruling that might exceed the $15 million total verdict. Anyway, be well. We'll talk to you soon.